Again, I'm David Carrillo. These are my colleagues, Brandon Strassner and Stephen Duvernay. So our basic presentation is that we want to run through the issues, the criticisms, the concerns about the draft. And rather than do it, sort of American litigation combative style, we thought we'd do it as a discussion. So our format is that we're going to pose questions to each other, and then we're going to walk through what we think are the responses to those questions. And the questions are ones that people have raised about the proposed new Constitution. We think there are good responses to all of them, as we will explain. So the first objection that has been raised is that constitutional change is inappropriate in times of crisis. And I have two responses to this. The first one is that crisis is the best time for change. Not to quote a Chinese proverb, I think there is one, but not for that reason, but because it's a motivating factor. In times of peace, the natural reaction was, yeah, things seem to be going pretty well, so don't fix what's not broken. Like, why do we need to do anything? Everything's fine. So the crisis is both a motivating factor and an opportunity. It illustrates for you what exactly is broken and what needs fixing. So from that perspective, a crisis is the perfect time to fix your Constitution, because you know it's broken. The second response that I would make to this point is that actually the crisis seems to have passed, which you might think takes the pressure off. But not really. It's actually, it's not a mixed blessing, it's not a double-edged sword. It's actually the perfect scenario, I think, because passions have cooled. The immediate danger is past. So there's no risk of taking a hasty, ill-considered, non-deliberative action and slapping something into place, like our friend from Catalonia was telling us about, and now they've been stuck with it. No, the danger is past. The immediate danger is past. But the underlying difficulty that led Iceland to the 2008 financial crash, that's still there. So you're not immediately suffering from the effects of it, but those underlying risk factors are still there. So it could happen again. So I think this is actually the perfect time, the perfect opportunity for Iceland to do this, because you know what will happen if you don't do anything. The immediate danger is past, so there's no risk of doing something hot-temperedly. And third, you've had a chance to work on this thing for going on 10 years now. So it's had plenty of consideration. I think this is a perfect time to do it. Brandon? The next issue that we're going to consider is the criticism that the present Constitution is hard to change, and rightly so. So for people who have been complaining that this has taken too long and it's really difficult and it's hard and I don't know if we can get this over the finish line because it's really hard. Well, the Constitution is hard to change, and it should be hard to change. How do you respond?
Well, Constitution should be hard to change, but I think what we should do is take a look specifically at how we changed the 1944 Constitution. It's actually pretty difficult. The fact that you have to have two Althingi sessions that involves a dissolution in multiple elections, and that both times in both sessions the amendments have to be adopted unchanged, that is pretty difficult. You have the final result confirmed by the president. You have to reserve amendment power only to Althingi, so there's a little bit of a reduced amount of popular involvement in an amendment to a foundational document for a country. This is really difficult. It seems a bit more difficult than I think other processes, and so while it is okay that a constitution is difficult to amend, I think this process is pretty difficult, and I'm not sure I would keep it in the new Constitution. And as we know, the new draft Constitution does not do this exact process. One thing I'd like to note as well first is that the draft Constitution does require this process to occur before it's implemented. So it is acknowledging this difficult process. It's baked into one of the last articles, Article 114, and it requires that it goes through this legal process. That said, I think there are concerns with it, is that the electorate's not really directly involved at all. And I think having that in, as many of our state constitutions here in the United States have, having that opportunity for a little bit more, not too much, but a little bit more popular involvement, I think ensures that the Constitution as a foundational document for a country reflects the will of all of its people. And I think the difficulty of this Constitution, how difficult it's been to amend, is reflected by the fact that it's never been extensively revised other than the 1995 revision. So, I mean, the U.S. Constitution here is considered a document that's difficult to revise, possibly too difficult to revise, and that's happened a few dozen times now. And yet, in contrast here, the Icelandic Constitution, only really one significant revision. I think that's a signal that it's just a bit on the scale of too difficult. And the next concern, I guess, that would come up would be, what exactly is the need for change? Why even change anything at all?
So there's two things that I'll focus on here, and they both relate to the circumstances of the current Constitution's adoption. It was adopted in 1944, as most of you know, largely based on the Danish Constitution. And in that regard, it doesn't reflect the political autonomy or the historical traditions of the Icelandic people. And as a secondary point there, because it was adopted in a time of emergency, in a time of independence, and that it was based, again, largely on a pre-existing document, it wasn't intended to be permanent or to solve every possible problem. And I think we've seen over the last 70 years and certainly the last 10 years that it certainly can be improved and modernized and can reflect the political autonomy of the Icelandic people. Back to Dr. Carrillo. The Constitutional Council's allegedly ambiguous legitimacy. What say you?
Steve, what's the issue here? I mean, I understand that people have alleged some ambiguity about the legitimacy of the council, but what exactly would that be? People were elected to it in a full and free and fair election. That's the essence of legitimacy. Now, I understand that there was a judicial challenge to it, and the election wound up being invalidated, but that again was cured by the Constitutional Council being appointed. Even to the extent that people complain about the Constitutional Council being made up of whatever inappropriate category of people you're alleging it was made up of, that also was cured by the Council's draft, then later being taken in by Parliament and modified into now its own draft. So you have a series of adoptions, a series of legitimizations. You might remember that America's Constitutional Convention in 1787, they were only sent there with a mandate to revise the Articles of Confederation. Instead, they came back with an entire new system of government, a whole new country, a completely different document. And there was an argument at the time of, what are you doing? You exceeded your mandate. Well, the states ratified it. The United States was born. It was approved. Problem solved. So at this point, if Alþingi actually adopts the proposed new constitution and the voters adopt it, that moots all of these concerns about the Constitutional Council's supposed illegitimacy. So my position is it's been resolved already, and adoption cures all ills. I don't see what the problem is. Brandon, here's the next question for you. There's been a complaint that this invades Alþingi's prerogatives in constitutional revision, that Parliament is supreme in Iceland, and so only Parliament should be considering revisions to the founding document. How do you respond?
Well, I think there are a few points to respond with. The first one is Alþingi was involved, perhaps not initially, but after the invalidation by the Supreme Court of Iceland, they appointed the members of the Constitutional Council. I think it's important for Alþingi to consider, and this goes through the whole entire draft document for the Constitution. The power of appointment is not to be underestimated. That's a significant amount of power that one wields in the process. So Alþingi has had a fundamental choice in the Constitutional Council. The other question I would ask, I guess, is what are these parliamentary prerogatives? They reign supreme, but what's the source of Alþingi's power? And I think one can debate that as a more underlying philosophical question. What is the source of government power, especially depending on the type of government? But if it's a democracy or
Popular
a republic
sovereignty
that involves elections with the will and the consent of the people, then the people are the source of Alþingi's power. And so their involvement in a process is not something that usurps the power of Alþingi, who derives their own power from the people of Iceland as a whole. And the final thing I would like to note is, as I mentioned previously, Article 114 in the draft Constitution requires that this process complies with the 1944 Constitution's amendment process. That's a part of the Constitution. It's a part of the original Constitution. There's nothing that's being done here that is not in the currently existing document in terms of the process that's required. So Alþingi I think, has nothing to complain about in terms of their involvement in this process. They've been involved. The process is legal. It's based on the old Constitution. And their power ultimately derives from the people of Iceland as a whole. So the next question or issue we have, and I'll throw this to you, Professor Duvernay, popular involvement rather than elite control makes us nervous. The population doesn't really know what they're doing.
I think this touches on a theme that Professor Landmore discussed when she was talking about how the popular constitution making broke open Iceland, where it's thought that to draft a constitution it should be left to legal professionals, to political professionals, that it's complicated, and that regular citizens don't have a voice or a part to play other than to vote up or down after it's drafted. But I think what we've seen in Iceland is that popular constitution making can build consensus. It can strengthen the legitimacy of the institutions, and it's not as simple as just being a group of people throwing something together. It's been a collaborative process. It's evolved over time, where you get stakeholder involvement, from politicians, from the legal professionals, even though it is a citizen-driven document, that it's not purely that, that you have a document that really does reflect the will of the people in collaboration from top to bottom. Professor Carrillo, let's talk more about the fear of the masses. The constitution-making process was made up of the people rather than politicians or experts. I mean, are we making too much of this?
Yeah, you say that like it's a bad thing, that the people were involved in writing this Constitution. To me, this presents the fallacy of the ignorant voter. If the people are so ignorant, why let them vote at all? Won't ignorant voters ignorantly choose ignorant representatives? It's circular, isn't it? I think it proves too much is the basic problem. Another way to look at it is, basically if you take it to its furthest logical extent, it's an argument for eugenics. Why have voters on juries? Shouldn't experts be deciding cases? Shouldn't everything be decided from the bench by judges? Shouldn't laws be written by experts? In fact, shouldn't there be an IQ test for voting? Carry that to its ultimate extent. You'll have like the one smartest person in Iceland who gets to decide everything. It's the opposite of, yeah, exactly. So I don't buy the ignorant voter premise. If anything, look back at history. Look at the Magna Carta. Look at the U.S. Constitution. It was written by feudal barons in medieval times and farmers. Somebody pointed out earlier today that Thomas Jefferson was a farmer. Was he an expert in constitution writing? No, he was merely a wise person who put his mind to it and thought about it for a while. What would a good government look like? Well, we've done that all day long. So I don't buy the ignorant voter proposition. I think it proves too much. Just because the people wrote their government document, that doesn't render it suspect. If anything, that makes it more valid in my eyes. So we're going to take one more pass at the contempt for experiential constitution writing. So Brandon, let me throw it to you.
Yeah.
How do you explain this contempt for constitution writing from below? How do you respond?
I understand the initial concern or criticism that this is a legal document, that you should have people who are trained in the law, who understand the law to do drafting. And it's an understandable concern. But I think I'd hit back to this first point here. And again, I'd love to get in debates about the empowerment of governmental authority for different types of government. We're talking about a democratic or republic government here, one where the voters are involved. They are the ones who are electing the representatives. They're the source of the power of the people. And I think the draft Constitution reflects this inherent principle. It's always been there. It doesn't matter what the 1944 Constitution said, whether it was explicit. It's inherent in this structure of government. And I think the preamble, leading with "we the people" and describing the purpose of this new Constitution, and noting that here in Chapter 1, Article 2, that Alþingi exercises legislative power on behalf of the nation, and they are elected by the people. So it's kind of hard when you're getting to a foundational core document that I think everybody in Iceland should be able to understand, should be able to be aware of. They should be able to read this document and know, at least generally speaking, what their rights are and how their government works. I think it's weird to have contempt for people who are not legal experts to write such a foundational document that reflects, I think, the values of the people of that country. This is not something that requires a legal education. We're not delving into the minutia of statutory interpretation or examining regulatory agencies or a very specific legal policy involving sophisticated actors. This involves everyone. And I think because of that, that contempt is kind of misplaced. And just to offer some other examples from this own state's constitution, there's an explicit statement there. All political power is inherent in the people, and government's instituted for their benefit, and the people have the right to alter or reform it when the public good may require. I think that's inherent to any form of constitutional participatory government, like a democracy or a republic. I don't think that's something that's odd or bizarre at all or anything we should have contempt for. It was a similar thing in the state constitution as well, that the people reserve to themselves certain powers. So this is not a matter of who gets what power that's dictated by a document. It's that the people come together, they write this document, they delegate powers to the government that they otherwise have. and that in some instances, such as the California Constitution, certain powers are reserved. That reservation of power shows that the power originates from the people and that they are handing it out to the aspects of government. And I'd also note, too, that there has been delegation in the Iceland constitution-making process. The National Forum in 2010, there were 950 attendees. They were not drafting. They were providing a large amount of input. This was delegated to 25 drafters. There were intelligent choices made throughout this process to make sure that people who were probably better choices for drafting were drafting. This wasn't some sort of ad hoc, 1,000 people are getting together and just scribbling things down on a document. There was a lot of consideration, a lot of delegation. And in the second process, Alþingi appointed constitutional council members. So there's been, I think, a fair amount of making sure that the people who are doing actual drafting are people who are trusted and have the kind of right level of expertise or knowledge or approach. So we do have, a document that reflects both popular sentiment and popular values, and a document that involves some careful consideration of, let's not have 1,000 people writing this all at once. So it wasn't a chaotic process, and I think that contempt is misplaced. And I think more generally, Professor Duvernay can speak generally on contempt for politics from below as a general principle, like what, the elite should be ruling or handling things. Nobody at the bottom knows what they're doing. They're not very well educated. They aren't political actors themselves. They don't know what it's like.
There's a lot of contempt on these slides. But I think this dovetails with Brandon's point about sort of these core concepts of popular sovereignty. The people have the right to establish and alter their government when they find it necessary to do so, when the public good requires. And what you see in 2008 and from 2008 till today is that the people of Iceland are having a constitutional moment, one that certainly captured the popular will and imagination, and for a people that can trace their political history back 1,200 or 1,300 years, I mean, far, far, far beyond the American experience. I think it's important to have a foundational document that reflects that history and the will of the people. And ultimately, it is the people who decide what their government sort of shall be. So the top-down contempt sort of has it backwards, because it's the government that serves the people and not the other way around. So fear of change. We're off the contempt slide and just onto fear.
What should we be afraid of, Steve?
I mean, change. I mean, fear of abandoning the status quo.
Should people be afraid of their governments or the other way around?
Well, probably both. But
I say don't be afraid of this opportunity for change. Embrace it. It's true that it's rare, and that scares some people. Oh, this is special. This doesn't happen every day. This is a once-in-a-lifetime thing. Well, yes, it is, and you should think about that. This is a once-in-a-lifetime opportunity for popular constitutional change without revolutionary struggle. That's incredibly special. So rather than fearing that, you should embrace it. Now think about it. The English did it in 1215. My country did it in 1776. The French, 1789, and the Russians in 1917. Great nations resulted. True, not without great struggle and sacrifice. And that's what's unique about this situation, is that you can change your country. You can change your foundational document. You can recreate your government without having to have a bloody revolution. So rather than fearing that opportunity, I'd take it in a hot second. Let me see the next one, Brandon.
Sure.
So now we're moving away from fear and contempt into process. And one of the big complaints about this has been that the process was not representative. We've touched on a couple of the factual issues here, but let's take this issue head on. How was this a representative process?
Sure. I mean, we could probably stop at my response being that right there. It's just plainly not true. So I'll touch back to circle back to what I said briefly before. In November 2010, you had 950 people selected at random. There's actually debate, I guess, depending on how scientific you are, that if you're picking a random sample, that's actually quite representative, or can be. So there's that to start with. But again, we had a drafting process from 25 elected representatives from that group. So I think that's fairly representative. And 950 people out of a population of around 300,000, I think that's way better than our own constitutional making process. We had a few dozen, fairly smart people, which was great. But this is extremely representative, both from a popular perspective and a principled, let's make sure we have the right level of people writing this perspective. Same goes for the council. I'd say it's a little bit less representative. You didn't have 950 people selected, at large from the country. The people who were drafting weren't elected or directly involved, but they were appointed by the Althingi, who were elected by the people. And then just to look as well, there was an advisory referendum. There were multiple stages of this where there was popular input from everyone. All the interest groups, I think, were represented. Althingi had a very powerful role to play in the Constitutional Council. And ultimately, in this advisory referendum, you have 64% voting in support. Again, different countries have different thresholds for what they think is a lot. I guess coming from, an American perspective and our low voter turnout and voter approval of anything, 64% to me is pretty darn high. So I just don't see how you can say after all of these multiple processes that it wasn't representative in various ways, both through delegation and through popular sentiment and popular involvement. And then, of course, we have a more specific complaint here that Professor Duvernay will address. Politicians were concerned about being excluded from the process. Shouldn't they be more involved?
Of course they were concerned about it because it directly threatens the power of entrenched politicians and interest groups. But as we've discussed, as I mentioned, as you've mentioned, it's not a purely citizen-driven, take all of the power away from the elected representatives. It was a collaborative process. It continues to be a collaborative process, both working with Althingi and other political interest groups, but also through the process itself, which requires multiple votes in Parliament. I mean, you need approval twice. I believe that's correct. You still have to comply with the amendment revision procedure from the 1944 Constitution. So, as we've seen, if the politicians were completely excluded from the process, the Constitution probably would have been adopted several years ago. They've managed to be very involved in the process, but also at various steps along the way. So I don't think this is a well-founded concern. Certainly, it's not surprising that these complaints would be voiced by people who could potentially lose power or influence, but I just think it's incorrect. Professor Carrillo, is changing Iceland's constitution a radical new idea? Is it crazy?
How is that? I think the right response is that it is neither radical nor new. One of Iceland's own former prime ministers advocated for constitutional change for years. So it's hardly radical if your own prime minister is advocating for it. It's hardly new because she was doing it fairly recently. It's also not a new idea historically because Iceland arguably has at least 2 and probably even 3 charter documents or organizing documents. So you've done this before, and as Brandon pointed out earlier, in 1995 there was a fairly significant revision to Iceland's constitution. So radical, no. New, no. Called for now, probably. But if the question is, this is something we should be afraid of because it's radical and new, first of all, don't be afraid of new things. And secondly, this isn't even that new. Last point I was going to make is that scholars have pointed out that because of the way Iceland's constitution was adopted, it was always assumed that it was going to be changed at some point down the road, which is fairly unusual for founding documents. If anything, as Brandon pointed out, it's the opposite assumption for our constitution. It's extremely difficult to change, and we've only done it a few times. But Iceland's the other way around. You guys have always expected to be changing your constitution. So what is everybody afraid of? So next question to Brandon. Now we get into something that's a little bit personal. Academics have complained about this constitution. They have criticized it as being suboptimal in the process that it was adopted. How do you respond?
Well, I guess before getting into the specifics, no process is going to be perfect, and I think it's also interesting to have this complaint after the process going through multiple different stages with different formats. But, and I wasn't involved in the process, obviously, so I'm not here to quibble with any sort of factual concerns or the disputes. I think I'm here to address, the inferences or the conclusions we can draw from these observations. So one of the observations was that there was the meetings had really tight schedules. You just had vague general statements of values that were produced, and a lack of in-depth debate. I don't think this is actually that much of a problem. Tight meeting schedules are unfortunate. I don't like them at my own job. they're not something, you want to make sure that people have time to be involved, to deliberate, to consider. So that could be a concern, but no process is perfect. And I think the important thing here to consider is that this process was about the core values applicable to many. So a constitution's not going to get extremely detailed, precise statements of a specific situation. That's not the purpose of the document. That's the purpose of your laws you pass afterward.
If anything, that's a complaint that people level against California's constitution because it has so much constitutional legislation.
Yep, and yeah, our own state constitution, it's extremely specific, it's extremely long. I think it, unfortunately, because of how long it is, it starts to, you don't read very far past the beginning of it because you start to realize you'll never get through it. And it turns more into kind of a series of statutes or laws. It reflects, at least the longer or the other parts of the Constitution don't reflect values as much as they do things that should be in statutes. And so I think having a document that has more kind of general statements of values, that way courts and Parliament, Althingi itself, can come in and fill the gaps later and be more flexible. I don't think that's a bad thing. And I think we had some other similar complaints as well that, when we're looking at the national gathering specifically, it's based on a model that businesses use to reflect clear-cut issues, which is not good for multiple complicated moral questions. I think that's a concern as well. We have a similarity there with a tight schedule of meetings. It sounds very business-like. This is more of about a philosophical debate about values. But at the same time, I think the issue is you can't debate this forever. I mean, I think it's been plenty of years of involvement in this process and consideration. I think the multiple stages have had a lot of deliberation and deep contemplation by the people of Iceland and those involved. And ultimately, I think the difficulty there is, you have debate and confrontation instead of collaboration and consensus. Sometimes you can spend as much time as you can having debate and not have an exact resolution. And then you have the result here, which has been complained about, is that controversial topics were avoided. It's kind of similar to that vague general statements produced. I think that's a good thing. If you have something that the people of Iceland as a whole can't really agree on, that's something I think that can be reserved for a statute or for the court to fill in or address later, and something that's flexible and more amenable to change than going through an entire constitutional revision later. Stick to your core values, stick to your common ground, and make that the Constitution. So I think if there's any concern here that the ultimate result was something that wasn't specific enough, that hard questions were avoided, that vague general statements are what came out, I think that's what you want a Constitution to be. So it feels difficult and unfair, and that this process, kind of had those results, and it didn't probably feel great to everyone involved. But I think at the end of the day, what you want is something that everyone can rally around, and then you let the statutes passed later deal with the specifics. And so we have kind of this criticism of kind of the problems with the elections, citizen involvement. They didn't seem to be very involved. So is this really just an indication like false self-empowerment? This whole power of the people thing is really not what's happening here.
Or I keep getting the contempt for the people slides. I think this group of process criticisms sort of reflects the fact that there's no blueprint for, the wholesale repair and replacement of a constitution. There was no roadmap for how to do this. And if anything, I think the sort of bumps in the road or path that constitutional change has gone through over the last 9 years reflects an adaptability and strength of both the Icelandic people and the existing governmental institutions in adapting to sort of the demand for change and to accommodate sort of how do we make this happen given our current institutions? How do we sort of work collaboratively at a resolution? So there certainly are defects in the process, but I think we are where we are, and that ultimately these sort of issues are canceled out and resolved through sort of just where we are now in terms of getting out there, getting people prepared to vote, educating the people, and getting the Constitution approved. Professor Carrillo, the process was too open or not open enough?
Well, the draft has been subjected to both criticisms, and at the same time, obviously, they cancel each other out. And so in thinking about this, I decided to reject the hypothetical. I think this is a false dichotomy. The reality is, look at the evolution. You had three things happened in series. You had a crowdsourced popular draft, you had something that was produced by a legislative appointed council, and then you had something that was produced by Parliament. Isn't that exactly what you want? You had citizen involvement, you had appointed council involvement, and you had elected representative involvement. And at the end of the day, it has always been contemplated that there would be a vote in Helsinki followed by popular ratification. So I don't care so much about any one of those drafts, the original, the penultimate, or the final. And as I said before, it really comes down to ratification, which cures all ills. But I think it's pretty fair to say at this point in the evolution that it was both open enough and both closed enough. It was neither too open, nor was it too closed. It was the best that anyone could ever possibly want. And I realize that it wasn't exactly intentional that it happened that way, but here we are. And that, I think, is the answer to that. Let's go to the next one, Brandon. So Brandon was talking about statements of intent, and constitutional scholars spend a lot of time talking about the different kinds of constitutions, whether it's a frame of government, expression of general principles, or whether it's more like California's, which is full of constitutional legislation. And the draft pretty obviously fits into one category rather than the other. But that leaves it open to the attack that is commonly made against frame of government documents is that it's too vague. It's statements of intent or general principles, and it is very obviously contemplated that some of the blanks are going to have to be filled in later. So that makes it sound incomplete. How do you respond?
I mean, I guess my first question would be, has the person who's leveled this, I mean, I've read the draft. It seems extremely comprehensive to me. I'd also like to note, too, that, and I think this is something that's coming up a lot, this is an evolution on the original. It's not a revolution. Things are just not thrown out. They didn't work from scratch. Some of the provisions, many of the provisions, are nearly identical or have slight modifications. This isn't something that's crazy and out of left field. The people who took the time to draft this document and collaborate on it really gave a lot of attention and thought about what changes they would make and how it would still reflect a lot of the core of the 1944 Constitution. It's more of an update. And from that, I think it's difficult to accuse the draft of being incomplete. The 1944 Constitution would have to be incomplete, and I think you've worked all right with a purportedly incomplete version of government for quite some time now. So it's hard for me to see this as an unfinished document. The multiple processes, the layers of approval, the 64% approval in referendum, all of this indicates that there is a kind of overall consensus that this is a complete, comprehensive document. And another thing that I've really enjoyed in reading the document is that it has the flexibility a Constitution needs. That does not make it unfinished or a mere statement of intent or insufficient. Flexibility in constitutional provisions for gap filling by Althingi in the form of statutes or from gap filling by the judiciary as needed later, that's a good thing. That's something you want in a foundational core document that's hard to change. One of the examples I like to look at is the election law. That's Article 39. It permits division into electoral districts for Althingi in elections. Does not require it. This is something that Althingi through statute can decide. Do we want 0 districts? Do we want up to 30? It sets a cap. It sets both a roof and a floor, and it permits the flexibility as the needs of your society change to go ahead and make the changes that you need that you think are better for your government. That flexibility is a benefit. It's not a bug. It's a feature. Althingi and the courts can fill out the contours on a lot of these provisions as needed. No constitution can answer all questions. I think that's the bottom line. And if somehow you had one that did that or tried to do that, I feel like California's tries to do that at times, it creates difficulties trying to do that. And if things are really needed in terms of amendment, there's an amendment process that's still difficult, but less difficult than the 1944 process. So there's no concern here, I think, that an unfinished document shows up and creates all of this array of problems. The flexibility permits Althingi and the courts to step in, and the amendment process is still difficult, but a little bit easier, so change can occur more often if needed. I think that on the whole, I'm really happy with the level of structure of government and the elaboration of the rights of people of Iceland that this draft document has. We have another set of competing complaints here. The draft is way too radical, or the draft isn't radical enough. How would you respond?
This goes hand in hand with the point you just made, which is that this is not a completely revolutionary document. It's meant to be an evolution, an improvement on the 1944 Constitution to address critical issues. to improve on on the existing institutions, and that sort of reflects, again, basic principles of framing documents, of foundational documents that, we enter into these social compacts to take a step toward getting better, to be more perfect in a classical American sense. But at the same time, it's an exercise in compromise. It reflects the people as a whole. If you're too radical, you're going to exclude, a large portion of the people. If you're not radical enough, well, I don't think that there's really a basis for it not being radical enough. Again, because it reflects the will of the people and not any one person or a small subgroup of people. It's naturally going to be toward the sort of median opinion of of the Icelandic people. Yeah. Draft changes too much, Dr. Carrillo.
So this is the third part of our three-part response to, the Constitution is too radical, changes too much. Well, I'd make 2 points here. One is, it's actually not all that different from many of the constitutions in Europe. I know we have some comparative con law scholars here and people who are very familiar with the charters of their own European nations, and I challenge you, compare them side by side and see just how radically different it's not, Iceland's constitution is. I think you'll find that they're fairly similar. The second thing is, for such a radical document, it's actually not all that radical. The most radical thing that we could find in it from our perspective were the new direct democracy provisions, which we thought were really interesting. There's been a lot of focus on them. And so that was the first thing we read when we took a look at this and started working on it. And we said, essentially, and I'm paraphrasing here, that's what you're worried about? So for people who spend a lot of time thinking about working with the California Constitution, which has very powerful, very heavily used, very frequently litigated direct democracy provisions, articles, 66 and 65, I don't want to say we laughed, but we were a little nonplussed at all the furor over these because they pale in comparison to California's. Not as a value judgment, they're just much weaker. And so we thought it was a little amusing that one of the attacks on this draft constitution was that it contained some radical new direct democracy provisions which were quite lukewarm, weak tea by our standards. One of them isn't even binding, if I remember correctly.
Yeah, it's not binding.
Right.
All thingy has the option to decide
Right.
not to employ it.
So it's effectively an opinion poll.
Yeah.
Which is actually interesting because fairly recently in California, we had a California Supreme Court decision where our state's highest court had to decide essentially exactly that issue. Our direct democracy provisions are exclusively directed at producing laws, statutes, amendments to our state constitution. And there was a real constitutional question about whether you could use an initiative in California that didn't result in a law, if you just wanted to know what the voters thought. That had to get resolved by our state Supreme Court. Exactly.
Yeah.
Yeah.
Yep.
So, again, not in a pejorative way, we're not being insulting, but we were mildly amused by the consternation over this because we frequently grapple with much more significant direct democracy actions. So radical, definitely no, not from our perspective. If anything, we were surprised that they weren't stronger. So Brandon, let me ask you this. You touched on this a little bit, but I want you to expand. Just how different is the draft from what Iceland has used before? We're talking about radical changes or, the degree of change. Is this really all that different from what Iceland has known up to this point?
I think, to return to a term we've used a few times, I see it as a strong evolution, not a revolution. And I think that's a good thing. One of the things that impressed me the most was the shift from, I believe it was Article 7 in the 1944 Constitution, the back of the elaboration of human rights, and moving those to the front. That makes perfect logical sense to me. It's not a huge substantive change. There are some changes in the way the rights are elaborated, or there might be one or two that were added in that I recall. But that just reflects more of a sentiment of the people and the idea that the people are the source of the power, and the first thing you should be concerned with are what are the rights of the people. Then we will transition into government structure. That's a stylistic change, and I think it's an important stylistic change, but that's not a radical change out of nowhere that just radically alters the structure of the government. We were briefly talking about, and I'll hit on those, the popular sovereignty provisions. By the way, I think it's okay not to have strong popular sovereignty provisions. Our Constitution changes a lot. Some people like it, many people don't, and they think there are concerns with that. So having a popular sovereignty provision, as Iceland's draft Constitution does, that gets the people's input directly involved with Althingi and permits direct participation in the process, but is not as strong as California's, it could be that perfect kind of Goldilocks, not too much, not too little situation. I think that's great, and I think just generally speaking, back to the change, embrace change. I guess if it's a bad change, don't embrace it. But if the change is good, as I think it is here, then there's no need to fear it. The preamble that was added in, it informs the intent behind the provisions. I think it's important. Yes, I realize it's not a substantive operative law, but it's something that's a message to the people of Iceland, that Icelandic children can read growing up as one of their things to see this is what our government's about and what our people are about. And it helps inform the intent behind the substantive provisions, say later on when the judiciary needs to interpret, or when Althingi is deciding what law to pass and looking at another specific article. Again, evolution, not revolution. I mentioned previously the shifting of rights from back to the front of the document, and then you have refinement of provisions. You're not turning much on its head. So back to the election provisions, Chapter 3, Article 39, there was, I believe, 6 to 7 certain types of a district, and now it's no more than 8. That's not crazy. That's just an adjustment to some of the new needs of the country. And I would like to note in the draft Constitution, there's more flexibility. It's now no more than 8. It can be from 0 to 8 as the country needs and adapted without having to go through a laborious constitutional amendment process. I think that's phenomenal. Throughout the whole document overall, just to speak on this briefly, there's a lot of use of law and may, that something may be done, which permits the flexibility for Althingi to do that or to not do that as needed. There's also a lot of use of this shall be, addressed by the operation of law. Here's a core value. Here's something we want to happen. Althingi will pass laws to make this happen. That's, again, speaking back to the structure of a constitution or a foundational document. That is a great thing, and it's not this crazy revolution that strips away power from the legislature. They have a lot of power to help guide how this Constitution works, and because of that, it's not a revolution. There's nothing in here that I see personally that's going to lock the country down in some sort of nightmare. That's just not it at all.
Brandon, can I ask you something? Would you go as far as saying that the changes are so slight that this isn't worth doing?
No, I think there are some differences here, and I think I like some of the accountability provisions, specifically the ombudsman of the Althingi. There's Articles 74 and 75 that provide a little bit more accountability and some direct interaction between the president and Althingi. There is, I think, perhaps one of the larger, maybe more cynical complaints in my view might be that, if I'm not mistaken, one of the new differences is that ministers cannot be members of Althingi. I personally view that as a separation of powers issue. Ministers are in the executive, members of Althingi are in the legislature. That's probably a good change.
But we come from a Republican tradition, so that makes sense to us.
That makes sense to us. Now, if that doesn't work out in Parliament, is that one provision something that should kill the whole Constitution? I think not. And I think if Parliament had that large issue with it, could they not change that one provision and pass the rest of it, or work with the country to do that? That's possible. But I think the changes are important enough to keep. I think it should happen. To me, it's more of I see it more as of a kind of almost I don't want to say it quite this way, but perhaps a no-brainer. This is not a hard decision. It is such a set of improvements that are not crazy or radical, but such a set of improvements that why would you not want to implement this? They all make, I think, the whole document as a whole better. And so, it's not going to flip anything 180 degrees or set the country in a different direction. But the provisions are such great improvements that taken as a whole, it just seems like this is a wonderful thing to do, and why would you not want to do it? And that's been my read of the document. So here's another question or issue Professor Duvernay will address. It's a political experiment without parallel in the countries of the West. It hasn't been done before. We can't rely on it. It's too risky.
Well, I think generally speaking, that's not a reason not to do something. But in particular, I think this criticism was levied at the direct democracy provisions, the initiative and referendum provisions. And certainly, we've got now a little bit more than a century of experience with direct democracy tools in the United States. California's were adopted in 1911, sort of at the forefront of a series of states that adopted them. But what we see in the draft Constitution, as Brandon pointed out, is that these are not as robust as we have in the United States. I think the direct democracy provisions, like what we'd call the separation of powers provisions, the accountability provisions. They're calibrated to the particular needs of the Icelandic people and your political experience. It's not, again, revolutionary. It's evolutionary, and I think that, I'll double down on what Brandon said and just reiterate that, taken as a whole, this is a significant set of improvements over the previous document that it seems to make perfect sense to adopt the Constitution. And no one of these particular provisions is radical or outside of the mainstream. Professor Carrillo, the academic community has substantial criticism of many articles in the Constitution. What say you?
The academics. We love to criticize things, don't we? I'm an academic, so I'm throwing myself under the bus. I know I have many colleagues in the room. I have two reactions to this. One of our colleagues this morning was talking about, her theme was "Don't have a constitutional convention in July," and one of her themes was, I think one of our other colleagues mentioned this too. If I had to do it over again, I would have done some things differently, and one of them would have been involving the academics earlier, which means not doing it in July when they're all on vacation. There has to be an element of peak going on here. You wrote that without me. I study this for a living. How did you unwashed heathens come up with that? There has to be something wrong with it. I will read this thing until I find something wrong with it. And that's also part of the scholarly function, is we pick things apart, we critique things, we analyze, we overanalyze sometimes. So I think there's a little bit of that reaction. That's my personal opinion. I don't have any evidence of it. That's my speculation. But I suspect that there is. What we can prove, though, is that, yes, it's certainly true that there were a number of academics who had a number of unfavorable things to say about this Constitution. But that wasn't the unanimous take of the Academy. It was actually divided. It's about half and half. So a bunch of scholars had their noses out of joint and complained about this thing substantively. But there were plenty of scholars that found a lot to like about it. So we think that the academic opinion is actually divided, and no conclusions can be drawn from that. So I'm going to turn it over to my colleague, who's now going to explain to us the skepticism and surprise of some scholars and the praise that others had for it.
Yeah, so one thing I'd like to point out here is we've seen some of the criticisms previously. I'd like to look specifically at the International Expert Report on the Draft Constitution. It was done by 3 constitutional scholars, and they had some findings, I think, that reflect, how our general opinion, I think, that this Constitution is in great shape. So it has a life expectancy of 60 years under their metrics, and the global average is 19. Seems like there was a lot of thought that went into it for it to get, 3 times over the average kind of expectancy for the age or the life expectancy of the Constitution. As we've discussed to no end, there has been significant input from the public and a lot of different groups. It was described as the cutting edge of ensuring public participation in ongoing governance. It sounds like a pretty good thing to me. And then, again, a lot of innovation, a lot of participation. The final result being one of the most inclusive in history and well above the means of contemporary constitutions. I'm a little jealous of it, to be perfectly honest. I think there's a lot of really good stuff in here that other countries could look to and incorporate into theirs when they make changes. I'd also like to note something about when this was published. It was published on the 14th of October, about a week before the referendum. The reason I highlight this is because this was a long process, and there were a lot of criticisms throughout. Criticisms of the process, criticisms of where certain individuals viewed the state of that Constitution or that draft as it was. This was a week before the referendum. This was a recent review that looked at what does this Constitution say now after all of this process, after all of the debate, just what does the document look like in its more final form than it had been throughout that process. I think we should always be skeptical of criticisms during an ongoing process and look more and put a little bit more weight behind the evaluation that occurs right at the end of it. What is the substance of this? What does this mean? The process was wonderful, but at the end of the day, what does the document do and how good is it? And I think there's a lot of weight to put behind this report because it evaluated that Constitution after the process was over and it looked at it as a whole instead of in the middle, in midstream while things are still developing. So, Professor Duvernay will address some of the other scholarly points here.
Yeah, so to piggyback on what Brandon was saying about the International Expert Review, the draft Constitution has been vetted by the international community. It's been vetted by experts. It was vetted by the Venice Commission, who again praised the inclusivity of the process, as well as the substantive scope of the draft Constitution. While there were some criticisms, many of which we've discussed and addressed on other slides today, on the whole, the review is positive. And I think one other thing you can note from this process is, once again, this is collaborative. The Venice Commission made its opinions known, and the draft was revised partially in response to that review. Once again, showing that it's been vetted, and it's been a collaborative and responsive process. Professor Carrillo, there is no political support for holding a vote.
That's not true. It's just not. Look at the numbers. They don't lie. Does anybody need me to explain that to them? I don't think so. It's just not true. Moving on. Brandon, if you ignore the referendum at this point, and this is the referendum I'm talking about, what was the point of holding it in the first place?
Yeah, so this criticism, that's kind of, I think, the bottom line point I arrived to with this. There are some explanations for inaction, is that the referendum was merely advisory, that members of Althingi are bound solely by their conviction, not by any instructions from their constituents, which is true. And by the way, that is in essence carried over in the new Constitution, so there's no radical changes on that going on either. One of the critiques as well was that, when you deal with advisory referendums, you should really be putting clear questions with a clear answer to the people. I understand that very much as someone who deals with California initiative measures. I understand that critique. When you have open or unclear questions, political groups can kind of step in and offer different interpretations for the results, make claims about those who did not vote. But I think one of my specific responses to that would be, those who did not vote in the referendum, they delegate their power to those who do. And those who do voted in a large margin to support this new Constitution. And I think the last thing to ask is, why do you hold a referendum and do nothing about it, especially when the results are so much in favor? Resolve any concrete issues if you have to, or rely on your own power as Parliament to use statutes to gap fill and the judiciary later to do additional gap filling. There's nothing detrimental in this document that's going to crash the country. You can fix the little nitpicky issues later down the road. And then for another critique, the people have lost interest. We're all tired of this. We don't want to deal with it anymore. Why bother continuing?
Well, just because it's sort of an issue that may have lost traction in the public imagination doesn't mean it's any less important. And I don't know that it has. Certainly over time, the issues receded into the background as people become concerned about other things. I'm also not sure how much weight to give any one single poll, but as a matter of momentum, I think this just shows that you need to get people energized and educated and reinvigorated about the process and about the draft Constitution. Simply because people are less interested now than they were 5 years ago is not a reason to not pursue constitutional change, particularly on a matter of such great importance.
Bottom line at Fortis, Brandon.
Take it away.
After hundreds of years of experience of Constitution writing, it's just not that hard anymore, particularly for a frame of government document like this. It takes no special skill. So the fact that the people participated in writing it shouldn't frighten anyone.
It still requires careful thought, attention to past mistakes in the old Constitution or other countries' constitutions, and reference to examples, as was done here. This draft has all three of those characteristics. It has careful thought, has attention to past mistakes, it references examples.
Yes, and the draft Constitution isn't meant to solve all problems, but it has mechanisms and procedures in place to allow government to efficiently address whatever may come in the future, either through Althingi passing laws, through judicial interpretation, through the people using the referenda and initiative power, to fill in the gaps.
Penultimate slide. Last issue. Has the constitutional moment passed? We say only if you let it.
And if you let it, then you miss a once-in-an-age opportunity for self-determination.
And when the next crisis comes, if you don't do anything, it's on you.
Bravo. Thank you.